City of Ocala, Florida v. Art Rojas et al. On petition for writ of certiorari to the United States Court of Appeals for the 11th Circuit. Decided March 6, 2023. The petition for a writ of certiorari is denied. Statement of Justice Gorsuch respecting the denial of certiorari. Faced with a tragedy, the city of Ocala, Florida, searched for ways to bring the community together. After a shooting spree left several children injured, police appealed to community leaders for help. A local NAACP official suggested to the chief of police that he contact religious leaders to facilitate conversations between residents and law enforcement. A local minister, in turn, proposed holding a prayer vigil for the victims. The chief agreed to organize the event, and police chaplains participated in it. But instead of unity, litigation followed. Several atheists who chose to attend the event sued the city, alleging that the event's religious themes violated the First Amendment's Establishment Clause. Eventually, the district court granted summary judgment in their favor. The court reasoned that individuals enjoy Article 3 standing to contest religious speech they find offensive, and that the vigil violated the Establishment Clause under the terms of Lemon v. Kurtzman, 1971. On appeal, the 11th Circuit agreed that at least one of the plaintiffs had standing to sue, noting that she had direct contact with the prayer she found offensive. It didn't matter that the plaintiff went to the vigil knowing that she would be offended. What mattered was that prayers reached her ears. Still, the 11th Circuit vacated the district court's decision on the merits, remanding the case for reconsideration in light of this court's intervening decision in Kennedy v. Bremerton School District, 2022. I do not doubt that the district court must reconsider the merits. As this court explained in Kennedy, the Lemon test on which the district court relied is no longer good law. But the question of standing must be reconsidered too. This court has never endorsed the notion that an offended observer may bring an Establishment Clause claim. Elsewhere in the law, we routinely say that Article 3 demands a more concrete and particularized injury. And the same rule, we have said, applies in the Establishment Clause context too. Why, despite these teachings, have some lower courts indulged the fiction of offended observer standing? At least some of the fault lies here. In Lemon, this court suggested that the Establishment Clause forbids anything a reasonable observer would view as an endorsement of religion. For this to be so, lower courts deduced, such an observer must be able to sue. But if that logic ever made sense, it no longer does. In Kennedy, this court put to rest any question about Lemon's vitality. We held that claims alleging an establishment of religion must be measured against the Constitution's original and historical meaning, not the sensitivities of a hypothetical, reasonable observer. And with the demise of Lemon's reasonable observer test, little excuse now remains for the anomaly of offended observer standing. The gaping hole it tore in standing doctrine in the lower courts should now begin to close. The city asks us to take this case to make just this point. It is an understandable request, but I see no need for the court's intervention at this juncture. This case remains in interlocutory posture. the 11th Circuit has remanded the case to the District Court to permit it to consider Kennedy's implications in the first instance. I would allow that process to unfold. Moving forward, I expect lower courts will recognize that offended observer standing has no more foundation in the law than the Lemon test that inspired it. If I am wrong, the city is free to seek relief here after final judgment. For by now it should be clear that in a large and diverse country, offense can be easily found. Really, most every governmental action probably offends somebody. No doubt, too, that offense can be sincere, sometimes well taken, even wise. But recourse for disagreement and offense does not lie in federal litigation. Instead, in a society that holds among its most cherished ambitions mutual respect, tolerance, self-rule, and democratic responsibility, an offended viewer may avert his eyes or pursue a political solution. We've come to the end of the opinion. Until next episode, thanks for listening to What SCOTUS Wrote Us.